we got to go talk about SCOTUS. SCOTUS is happening. There's two very important cases being heard by this term. We're going to cover them both. We will go over to, of course, SCOTUS blog for the best analysis recap you can get in under 5 minutes. Let's go ahead and watch.
Did a Supreme Court justice reference AshleyMadison.com during oral argument today? Yes. Yes, he did. But we'll get to that in a minute. Today's case is about a website designer in Colorado who does not want to make custom wedding websites for same-sex couples. This is her. Her name is Lori Smith. Colorado has a law that says businesses open to the public cannot discriminate on the basis of sexual orientation.
The law in Colorado spawns upon the Civil Rights Act. The Civil Rights Act does not allow people that have public-facing businesses within certain sectors, housing, hospitality, and there's some other ones. Housing and hospitality are the two big ones. I think gas stations. There's a whole slew of them. And it's been expanded on since. Disabled people were added to it, for example. For people based on race, ethnicity, gender, sex, gender, national origin, and religion. The Colorado has a law that adds sexual orientation, and I believe it adds gender identity to this as well. Now, with that said, there are competing interests here. There is the competing interest of free speech and free association, with the competing interest of having a pluralistic society that is integrated and well maintained. Those are the competing interests to a degree, especially since we allow religion to be included in that. We allow people's religion to in that as well. So we don't want people to not be able to fully practice their faith, and so that has a natural tension in some regards for things like this. Well, let's go ahead and continue.
Smith says that violates her right to free speech, specifically her right not to build custom wedding websites for same-sex couples. Today's oral argument lasted over 2 hours with lots of hypotheticals from the justices. Justice Sotomayor asked if Smith were to win, could she also refuse to design wedding websites for disabled couples if she had a sincerely held belief that people with disabilities should not get married?
Before we let SCOTUS blog continue on with this, there's already a good compromise here. It's very simple. It exists in the current public accommodation laws. We'll talk about it after this video, but it has to be said here that people are being disingenuous when they said there isn't one, but we're going to talk about it. And also, yes, under the current law or the current precepts of what this is, sincerely held religious beliefs do come into conflict with with these other rights, these other integration rights, because we're not going to actually look at someone's sincerely held beliefs and give them a religious test. We don't do that. So if it's my closely held religious belief that I don't want to serve you for whatever reason, that comes into conflict with these other rights.
That's because the same law that covers sexual orientation discrimination also prohibits discrimination on the basis of having a disability. Now, Justice Jackson asked about the implications for race discrimination. For example, could one of those holiday photographers at the mall say, hey, I want to take old-timey Christmas photos this year with vibes like the holiday classic movie, It's a Wonderful Life. So, no pictures of Black children sitting on Santa's lap because that doesn't fit with the artistic message the photographer's trying to send. Justice Alito tried to draw a line between opposition to same-sex couples and opposition to interracial couples. Alito cited Justice Kennedy's opinion in Obergefell, saying honorable people disagree about same-sex marriage, but the same can't be said for disagreeing about interracial marriage. He's also the culprit behind the Ashley Madison reference. Here it is. Like Justice Jackson, he was comparing the work of a wedding website designer to that of a photographer. He says, what if a single Jewish person asks a Jewish photographer to take his picture? We can use it in his JDate profile. That's a Jewish dating service, I gather, he says. Kagan says, it is. There was a lot of laughter, and then he says, maybe Justice Kagan will know the next website I'm about to reference.
It's kind of ridiculous that these kind of questions come up because they're not personhood arguments. So, of course, you can deny service in a law that allows you to deny service to people that isn't based on personhood arguments, right? Like, how are these connections not made? I don't understand it. I really don't. I don't.
Changes the hypothetical, and he said, what if the guy asked the photographer to take his picture not for a JDate profile, but for a profile on ashleymadison.com? The photographer have to do it even if he disagrees with the message that Ashley Madison sends? Justice Barrett asked, well, if the government wins, then would an LGBTQ publication whose entire reason for existence is to celebrate and promote same-sex marriage have to feature heterosexual couples if they were asked? After oral argument, it looks like a majority of the court's conservative justices are sympathetic to the website designer's cause here. Again,
Yes,
this case will clarify whether business owners who are engaged in expressive activity like website design will be able to get an exemption from laws protecting civil rights. We'll get a decision by the end of the term, likely by the end of June.
All right. So let's before we get into the next case, which is, I would probably say, more important just because of its implications. That's the tension. I get it. Quibbles. Sorry, there is a 15-second delay because I no longer pay for Restream. So there's already, like I said before we finished, there's already a compromise here. And that compromise was ruled in, was actually baked into the civil rights law. And that is members only clubs and organizations and referral only businesses. It does mean that potentially you're going to make less money. I acknowledge that. But if you're going to have a public-facing building, we'll just say storefront, not a building, storefront, online storefront, whatever, and you're not going to offer your services to everybody in the public based on their personhood characteristics, race, religion. I don't like to consider personhood stuff, but it's part of the civil rights, whatever, okay? So race, religion, ethnicity, age, gender, sex, nationality, and then in the case of Colorado, sexual orientation, gender identity, and disability, which is also another thing that we have to take. Then you don't want to do that. I'm not going to force you to do that. What I am going to say is that you should make that service referral only. And I understand that this is kind of just like putting the bigotry under the rug, and I get that, because it allows a person to just be like, oh, we're member only. You have to get a referral from these people, and then you can just direct them to a church, right? Like we only do wedding photos for weddings hosted at these places, or we only build websites for people that are whatever, right? We only build wedding websites that are hosted at these places, and those places can be religious institutions that are allowed to outrightly discriminate. And I don't think people would care about that as much. What I think people care about more is going to a place and expecting to be treated with respect, and then not being treated with respect. So I really think that this is actually how you thread that needle in a way that keeps a pluralistic society going. And I know that a lot of religious people don't like this, but they have to understand that when they actually say, hey, it's against my religion to serve you, what the implications of that are, and how in a pluralistic society that comes across, and how much inherently disrespect, even if you don't mean it, to be disrespect, it's going to come to a person. So I think that is what should happen with these things. The likely thing that's going to happen here is that they're just going to be able to turn people away because that's the Supreme Court that we have. I don't like that. I think that it should be, if you're going to be discriminatory based on race, creed, or whatever, then you should be members only, because that's baked into the law already, and everyone accepts that. No one wants to do business with a group of people that are outright bigots, and they'll be like, oh, okay, I get what's going on here. Bye, right? But when you go to it, and then in the case of the Baker one that started all this, there was two cases, actually. The other one doesn't get talked about as much. And the reason the other one doesn't get talked about as much, because the process of that one was more in your face bigoted. So the second case, and I don't remember who it was, I don't remember the exact details, name of the person, the city it was in, etc. Right? I don't remember those details, but I do remember the broad details. So the second case was a woman went to the baker with her mother and ordered a wedding cake. She ordered the wedding cake, and the woman's like, oh, that's great. You're getting married. What do you want on your cake? Let's do this, right? And then she showed up with her wife, or her soon-to-be wife, to pick up said wedding cake. It was the day of the wedding. Day before, whichever, right? Clearly not enough time to get another custom-made wedding cake. The woman refused to give them the cake and insisted that they take their money back. I'll say that again. The woman refused to give them the cake and insisted that they take their money back. She was perfectly fine making the cake before she knew it was for a gay couple. When she found out it was for a gay couple, that suddenly turned her away and made her not want to do it. It was already done. Can you really, like, can you see why Republicans and conservatives and religious people aren't talking about that case and are focusing on the master cake baker who turned them away at the onset? I think it should be clear, because that one makes everybody go, oof, that's not right. That's the thing. Now, quibbles over coffee. You're a great dude, man. So I like it when people point out these tensions that are actually important. And Quibbles Over Coffee said, there isn't just a matter of personhood, there's a question of whether it's a product or commissioned art. If it's commissioned art, it needs to be legal to discriminate. Actors should look like we want actors to look like, for example. That should be fine. If it's a website, which I think it probably is, you should be able to allow to discriminate its design, not who can use the site, but for its design, for example. Just as an architect should be allowed to reject a building by a client they disapprove of for whatever reasons. This is the argument that people should make, because it's a harder one to actually come to an agreement on. It really is. Because we don't want to necessarily compel people to speak. Now, when it comes to a website, is that really artistic? Is a wedding cake that looks just like every other wedding cake artistic? I'm hesitant to say yes, because they're so cookie cutter for the most part. And honestly, in most instances, the person that is getting the cake designed is going to come in with, like, this is what I want my cake to look like. And it's really just rendering that by a person that can actually do the work. Same thing for like a wedding website. Honestly, most wedding websites are just templates anyways, right? They're a website that you can drag and drop images in and you're good to go. It's not these aren't bespoke industries necessarily. So that's why I'm hesitant to say that it's yes. I understand the argument, and that's why I'm hesitant to say yes, and I'm hesitant to say no. I understand, okay? I don't want to make it seem like I don't understand. I understand this tension. I just think that if we are going to have an actual pluralistic society, then the cutoff for when you can deny service should be based on things that a person cannot control. So that's the cutoff. If you can't control it, you should give them the service for it. If you can control it, then you can discriminate. I think that is the line that we should draw. There needs to be a line, and that's where my line is. And like I said, I do believe that if this is something that we need, we agree that there's tension there, and we want to be able to allow this tension to diffuse and make everybody as happy as possible, then the other example would be if you do custom things and you don't want to serve everybody with those custom things based on their personhood, then you should go to referral only. Referral, closed shop, subscription, what have you. It should be referral only. You should only be you should get referred. It should be members only, and then the membership and then that is already baked in to the public accommodation laws in the Civil Rights Act. That's why you can have private KKK bars, okay, or whatever, like services, whatever. Like that's why these things exist, and they're not like done away with. Country clubs are another example of these private clubs that can discriminate based on membership. But I think that is the actual thread for this needle. So Quibbles is saying, but that can't be the cutoff across the board. You can't control being a man, but you probably shouldn't be getting certain roles on Broadway as a result. I mean, sure, but this isn't that, right? I should be able to make art that is representative of my political view. Yeah, No, I agree, but this is, so you should be allowed to make art that is representative of your political view. And I think that if you're a business and you're operating for profit and you're operating within a public facing entity, then boom, cut off there. That's where the line should be drawn. We can debate about it at some point if you would like. Maybe we can flush this out, but that's where I'm at. And I've been at that position for at least, well, since before Obergefell, honestly. With the commissioned part of it, I don't see the difference. I don't see if it's flat or if it's a commissioned work if you're offering it up to the public. But that concludes that segment.